What if I told you that the biggest threat to your electrical license in North Carolina has nothing to do with your wiring? You could pass every inspection, code perfect work, and still find yourself in front of the State Board of Examiners of Electrical Contractors, defending your license. Because in North Carolina, the wrong job, not the wrong wiring, can cost you your license. Picture this. A general contractor you've worked with before calls with a bigger project than usual. Good money. You're more than qualified to do the work, so you take it. No big deal, right? Well, 6 months later, a certified letter shows up. Not from an unhappy customer, from the board. And the complaint came from a competitor who lost the bid to you. That happens across this state more often than you think. And the violation isn't about workmanship. It's about a number printed on your license that you may not have looked at since the day you passed your exam. My name is Nick Dogle. I'm the owner and founder of North State Law here in Raleigh, North Carolina, and my practice focuses on professional license defense, representing licensed professionals when their livelihood is on the line in front of a regulatory agency or board. If you're an electrical contractor in North Carolina, limited, intermediate, or unlimited, this video is for you. We're covering one of the quietest ways electricians get into trouble with the board: working outside your license classification. I call it a silent license killer because there's no alarm. Project goes fine, the customer's got a smile on their face, they're super happy. The violation is sitting in your paperwork the whole time though, and you may not hear about it until someone else points it out to the board. North Carolina doesn't just license electricians, it categorizes them. Under Chapter 87, Article 4 of the General Statutes, licenses come in tiers, with hard financial ceilings on the size of projects you're allowed to take. Why? Great question. Because in the board's view, a license isn't just proof you can bend conduit and wire a panel. It's a representation to the public about the scale of work you've shown you can manage. Bigger projects mean bigger crews, more complex supervision, and more consumer money at risk. So when a contractor exceeds their classification, the board doesn't see ambition. It sees a contractor operating without a license for that category of work. And here's what professionals consistently misunderstand. The board doesn't have to prove your work was bad or that anyone was harmed. The dollar figure on the contract can be the entire case. I've actually had cases like this, and that is 100% true. Let's get the structure on the table. In plain English, as of June 2026, limited license, a single project valued at no more than $60,000 with equipment rated no higher than 600 volts. This is where most contractors actually start out. Then you got intermediate license. This raises the ceiling to $150,000 per project and requires you to show bonding ability. And unlimited, there is no project value cap on that one. You can do a project up to $2 billion if you got that. There are also special restricted classifications: elevator, low voltage, and so on and so forth, that limit the type of work rather than the dollar value. But today, it's the dollar caps that matter, and that's what we're going to be discussing in a little bit more detail. Now, two details that trip people up. First, the cap applies to the total value of the electrical project, not just your contract price. It refers to wiring, materials, equipment, and installation. They all count. Even materials furnished by someone else, like an owner or a GC supplying the fixtures. You can be over the limit while your own invoice looks safe. I've seen people make that mistake a lot of times. Second thing, you can't engineer around the cap by splitting the job up. If one project is subdivided into multiple contracts, the board's rules look at the combined value going to a single licensee. You got two 40,000 contracts on the same project, and that's isn't two compliant jobs for a limited license. It's one $80,000 violation. Most contractors memorized these numbers for an exam years ago. Meanwhile, their business grew. They're doing great. That's exactly where the trouble ends up starting a lot of times. These cases almost never involve someone deliberately ignoring the rules. They involve ordinary business decisions that quietly cross a statutory line. And almost never is the actual work subpar. Usually the work's fine. But 3 patterns come up again and again. Pattern 1, the project that grows. You bid a job at 55 grand, comfortably under your limited cap. Then come the change orders. A sub panel here, an upgraded lighting package there, material prices jump mid-project. By completion, the total value is now $72,000. Nobody decided to violate anything. The project simply grew past your license while you were busy doing the work. Pattern 2, supervision that isn't really supervision. Every license needs a listed qualified individual, and the board's rules define supervision strictly. Active on-site review of the work by a qualified individual while the work is in progress. Not phone check-ins, not photos at night. If you're the qualified individual for job sites you rarely visit, the board may conclude the work wasn't performed under your license at all. And the rules treat consistent absence from the job site as evidence of malpractice. So, pattern 3, the borrowed license. This one happens way too often. The most dangerous one, and as a matter of fact. Someone has the skills but not the right license and asks you to, just pull the permit. It feels like you're just helping out. But the rules are explicit. Your license number can't appear on a permit unless the work is done by you or your employees under your supervision through completion under a contract you hold and unless you receive all the payment. Lending your number fails every single part of that test. The common thread in all 3 patterns, the wiring might be flawless, the work done exquisitely. The violation lives entirely in the paperwork though. Now, and this is where most professionals get into trouble. These violations almost never surface the way you'd expect. Typically, it's not the customer that files the complaint. A lot of times, the customers are absolutely thrilled with the work done. The complaint typically can come from a competitor. North Carolina's construction markets are growing fast. Bidding is competitive and license classifications are publicly searchable. When a limited licensee wins a $120,000 job, the contractors who lost that bid are going to take notice, right? And some of them do the math for the board. Permit offices can trigger referrals the same way when an application shows a project value above the contractor's classification. And once a complaint lands, contractors make it worse in predictable ways, firing off an over-explained response the same week. Sometimes that's an angry response, and that's not good either. Or they'll be cleaning up contracts after receiving notice or assuming good work makes the case go away. Each of those instincts can turn a manageable classification issue into a credibility problem. And credibility problems are what turn warnings into discipline. Let's go into a hypothetical and we'll make this concrete. Let me make this concrete. Marcus holds a limited license. 8 years in business, good reputation. General contractor he trusts offers him the electrical package on a small commercial upfit. $120,000 total electrical value. Marcus knows his cap's 60 grand though, but the GC suggests an easy fix. Wow, we're just gonna split that into 2 contracts. Rough end under one, finish work under another, each around 60 grand. Feels like a technicality. The work is well within Marcus's ability. Project goes beautifully, passes every single inspection the first time. 4 months later, Marcus gets a letter from the board. A competing contractor who lost the bid filed a complaint attaching the permit record showing the combined value. Notice what's happened here. No allegation of bad work, no injured customer. The entire case is arithmetic. One project, one licensee, $120,000 of combined value, a $60,000 classification though. Splitting the contracts didn't create 2 compliant jobs. It documented 1 violation in writing with Marcus's signature on both halves of it. And his strongest instinct, but the work was perfect, is the one argument the statute doesn't care about. And if the statute doesn't care about it, the board certainly will not care about it, unfortunately. So what happens to someone in Marcus's position? Without giving legal advice, every case turns on its own facts. Here's the general landscape. Classification violations are largely strict liability in character. The question is whether the project exceeded the license, not whether you actually meant to break the rule. But intent matters enormously to the outcome. There's a meaningful difference in mitigation between a project that just happened to drift over the cap through change orders and contract structured to disguise a project's value. How the situation is presented and documented can influence whether a case ends in a warning, a fine, probation, or something that threatens the license itself, like a suspension. And here's a detail that surprises almost everyone. You generally can't fix this after the fact by upgrading your license, although that can be helpful. Under the board's rules, a licensee found working beyond their classification is ineligible to upgrade or even sit for the exam until the commitment to the offending project has been voided and the project re-awarded to a properly licensed contractor. Time to upgrade is before you take the job. Afterward, that door closes. One little caveat to that: if the project is already done and over with, getting your upgraded license could help in the mitigation going forward with the board. And one more thing about timing. When the board sends notice of a charge, the rules contemplate a written response within 20 days. What we often recommend in broad terms is treating that first letter as the most important document in the case. It's far easier to present a case well from the beginning than to repair a damaged one later. Here's the risk in one sentence. In North Carolina, taking a project above your license classification can be treated as unlicensed electrical contract, even when the work itself is absolutely flawless. And the takeaway here: ambition grows businesses, 100% true, but overreach triggers enforcement. The contractors who scale safely upgrade their classification before their contracts outgrow it, not after a competitor does the math for them. The classification system isn't unfair, but it is unforgiving. It doesn't weigh your intentions or your craftsmanship. It weighs your contract value against a number on your license. Keep those two numbers in the right order, and this entire category of risk disappears. If you've received a letter from the State Board of Examiners of Electrical Contractors, or you're looking at a project and you're generally not sure where it fits your classification, that is the moment to get guidance before you respond or sign. Decisions made in those first days matter more than most people realize. I'm Nick Dogle with North State Law. Thank you so much for watching, and stay on the right side of that number. One last thing, this video is for educational purposes only. It's not legal advice, and watching it doesn't create an attorney-client relationship. Every licensing matter turns on its own facts. So if you're facing a board complaint or investigation, talk to a licensed North Carolina attorney about your specific situation.